Hello everyone. We all know that the immigration process takes way too long, and sadly sometimes during this process the person that sent in the application, your parent, spouse, sibling, passes away. So what do? Is your application now void and you must start over? Today I answer some of these questions. I'm Raluca Hanea. I provide immigration, estate planning, and family law services for my clients. My marketing and office manager, Nina Clear, is here with me, and we thank you so much for all your likes, comments, and shares as they can help others to see our videos.
Let's help people first understand who is who on an immigration application. So, because there's petitioner or beneficiary, other terms, and they can be really confusing.
They can be confusing. For this video and with most applications, the person who files the application is the petitioner. The person who is going to receive the benefit, such as a green card, is the beneficiary. To be clear, this discussion would only be for someone, a petitioner, who has filed for a green card for a relative, which is the beneficiary. We will also mention derivative beneficiaries. This would be a person that would come with the main beneficiary and get a green card because they got one. An example of that would be minor children or a spouse of the beneficiary. We hope this helps people understand during this video, but if you have questions, please post them below.
Okay, so we have a parent, spouse, sibling, or child, so any of those really, who files an I-130 or an I-485 for someone, and before it is approved, they die. What happens?
With all of this, the result would depend on where you are in the process, meaning what applications were filed and what has been approved. Also, you must look at the petitioner's or your relative's status in the United States, if they are a citizen or a green card holder, and how you were related to them. It matters: child, spouse, parent, sibling. Where do you live? You are in or outside the US. And if you have any other relatives in the US who could be a financial sponsor. So these are all factors that matter. But first, let's talk about a US citizen dying before they file anything.
Okay, so this is before anything is filed and they die, but their spouse or their child might still be able to get a green card, right?
Yes, under certain circumstances. And to remind everyone, this is a very general information that we share, and we recommend that you talk to an attorney about your own situation. So if the US citizen dies before they file an I-130 for their minor child or spouse, the child or spouse may be able to file an I-360 and still immigrate to the United States.
Are there restrictions?
Yes, they must meet certain criteria, and that is why we recommend talking to an attorney. Two of the biggest are that it must be filed within 2 years of the US citizen's death, and the spouse cannot have remarried.
Okay, and what about if someone has filed an I-130 and then died? What happens? So let's first talk about a spouse or a minor child.
If it was after they filed the I-130 but before it was approved, the I-130 is automatically converted to an I-360.
And that applies to minor children or spouses. So what about for other relatives?
Yes, if the death is before the beneficiary, also known as the principal applicant, has immigrated to the United States, then the application is revoked.
And what do you mean by that, it is revoked?
It means that a consular officer will not issue visas for any of the beneficiaries on the application.
Is there any recourse?
If It's only one. And if there are compelling humanitarian circumstances, a consular officer may recommend to DHS, which is Department of Homeland Security, that they reinstate the application.
And how is that done?
I was able to do this successfully for a client. I submitted a legal argument explaining the circumstances to the consular officer. The consular officer notified DHS, and DHS determines if it should be reinstated. And if they agree, it should be the consular officer that will contact the beneficiaries.
So it's kind of a circle. First, the consular officer tells DHS,
yes,
there are humanitarian circumstances, and DHS agrees, and then tells the consular officer, and then the consular officer can tell the beneficiaries, okay, now we're going to move forward again. You're going to have your interview and all those things, right?
Yes.
Okay. So we had someone call here, and they said they had been told that as a sibling, because everybody talks to all their friends
Yes.
about what's happening, that they could take the place of the original petitioner who had died. But what I'm hearing is that that isn't always possible.
Especially not on the day of the interview. It is not possible to go into the interview and say, my father died, but my sister will sponsor me. Also be aware that it depends who is sponsoring you, and you may be qualified for on a different category. So the time that you must wait for the visa can change. DHS must have determined that the case should be reinstated and inform the consulate of this before the interview. Then the person who wants to be the substitute must qualify and submit an affidavit of support.
And what you also just said is if they're a different category, then your priority date remains the same, but
it can change.
Oh, it can change as well.
Yes.
And the date that your priority date comes up,
yes,
can also be impacted.
Yes.
So all of that is pretty tricky. Okay. So what about if the beneficiary has already immigrated to the United States and then the petitioner dies?
Well, if the beneficiary is already in the United States and they are already a legal permanent resident, they can remain here. However, if they had derivative beneficiaries who haven't yet immigrated, the derivative beneficiaries will not be able to get a visa at this time.
And what about if the beneficiary dies, but the petitioner is still alive? So can the derivative beneficiaries still get a visa?
Unfortunately, they cannot.
Could they apply for humanitarian relief?
Well, this is called humanitarian reinstatement, and unfortunately, derivative beneficiaries cannot.
So if the petitioner dies, it sounds like not all is lost.
That's right, but as we explained, because it can be complicated and you must meet certain criteria, I suggest talking to an immigration attorney as soon as possible if that happens. Thank you for all of you who watched, liked, and shared this video. Please call us with questions about your immigration case. We are always here to help. See you soon.